Mineral Resources and Energy Minister Gwede Mantashe says his department won't review the decision granting Shell exploration rights on the Wild Coast. He was responding to a parliamentary question following a scathing court judgment against Shell last month. The High Court sitting in Makhanda halted Shell's seismic survey, highlighting that the petroleum giant failed to adequately consult affected communities. Now, it said there was evidence that the blasts would irreparably harm marine life. The activity, as we've said time and time again, consists of air guns being blasted into the sea every 10 seconds, 24 hours a day into parts of the ocean. Now, Mantashe says his department believed Shell's survey to be legally compliant and most potential effects were significantly low. Well, I want us to get some reaction now from the Legal Resources Centre, who took the case to court. LRC lawyer Wilmien Wicomb joins us for more. Wilmien, thanks very much indeed for your time. So Minister Gwede Mantashe seems to be unmoved by the interdict to halt Shell's activity. That court decision made late last year. Is his stance materially significant for the future of this matter?
Well, on the one hand, it is not, because it is not up to him to decide whether the decision should be reviewed or not. It is for the court to decide, and that has not been decided yet. And, you know, he's also not entitled to allow Shell to continue because there is an interdict in place. So in that sense, it's not really significant. He doesn't have the power to do so anyway. What is significant, however, is that if a court decides that the allocation of the permit was invalid and that the decision must be taken again, it raises serious questions of, about the capacity of this minister to do so, given that he's so clearly come out in favor of the party that he is supposed to be the neutral adjudicator of.
And I suppose, the court issued the interdict. Shell has stopped the act.
On the ground, I think it's clear that Shell only had a window between December and, let's say, March, April to do the survey. So on the ground, nothing will happen, it is likely, before at least December of this year. And that is if Shell wins the appeal, wins the other interdict application as well, and even defeats the review, then best case scenario for them, I suppose, would be that they could be back on the water in December of this year. But we are very confident that that will not be the case.
Now, what if I can throw this in? I know you're not an economist, but I'm wondering whether the argument that the country's economic development is being oppressed in the name of environmental protection, does that hold any muster in court?
So that's a very interesting question, and I think this case was in some ways a landmark on that very question, because traditionally we've seen courts being very, very cautious when it comes to making decisions that would have the kind of significant economic impact that this decision did have and may still have in the future. And in this case, the court was not afraid to do so on the very simple principle that if you act unlawfully, then really you should be punished. And if that has huge economic implications, well, that cannot outweigh the rule of law. And of course, this case is not, at present, it is not a case about which, outweighs the other. Is it environmental considerations or economic considerations? We've not reached that stage yet. At this point, the dispute is about the fact that Shell did not take into consideration the impact that this will have on small-scale communities, for example. And that is the issue, right? So the balancing exercise is something that happens at a later stage, and we've not even reached that yet.
All right, fair enough. Well, that was Wilmien Wicomb. Thanks very much indeed for your time, an attorney at the Legal Resources Centre.